Judge Hugo G. Mack appearing with on behalf of Mr. Anthony Johnson. Mr. Johnson, please step up a little closer. Please state your name for the record, please.
Anthony Johnson.
Thank you. What are we doing?
Your Honor, a couple weeks ago, the prosecutor asked the court for 2 weeks to attempt to contact the alleged victim in this matter. I've been in contact speaking with Mr. Cook. They have not been able to do so. The rub in this case comes in that when you allowed them 2 weeks to contact the alleged victim, my client was in jail then and remains in jail now. Now, the reason he's in jail is because of this charge and he's on parole. The fact of him having this charge constituted a parole hold. So what happened, Judge, is that the court, because the court was going to set it for 1 week, I'm sure you remember, but Mr. Cook said, okay, I need more time. The court said, okay, Mr. Cook, 2 weeks. So they've had 2 weeks to contact this alleged victim. They have not done so. In conversation with Mr. Cook, he's saying, well, okay, well, if it's going to be a jury trial, then final settlement conferences are in August. So apparently what Mr. Cook is saying, even though the court graciously allowed them an extra week.
Right away, the defense is raising a major concern. The defendant has been sitting in jail while prosecutors try to locate the alleged victim. The question is simple. How long should someone remain in custody when a key witness can't be found? Let me know in the comments.
To contact the purported victim, he's comfortable with having my client stay in custody for.
I don't think that that's, Mr. Mack, I don't think, as I'm recalling everything, that was ever Mr. Cook's position. I mean, he wanted to contact the victim. I think he understood and appreciated the entirety of it. I think we all did. Quite frankly, Mr. Cook may not have been under an obligation to do anything. And if you wanted a jury trial, then you get set when it gets set. I'm sure he was going to try to use his best efforts, but.
So, Your Honor, what I'm asking the court is that in light of the fact that my client is in custody, the court has given the prosecutor great opportunity to contact the alleged victim. So first of all, I'd be asking for a motion to dismiss.
That's going to be denied. This would be the appropriate time. And, Mr. Mack, the problem here becomes, look, these kinds of things happen in DV cases. There's not a doubt that alleged victims disappear, then appear and do whatever. That happens. So what are we doing on this case?
Your Honor, if the court will not entertain the motion to dismiss, I asked the court.
It denied.
Okay, if the court's denied the motion to dismiss, Your Honor, my client informs me that I believe he's under a $20,000 cash or surety bond. My client will be exercising his right a jury trial. And in light of that fact, and the court's protocol is to only have jury trials every other month. So in other words, the next jury trial.
Not my schedule. That's set by other people. I'd have them every day if I could.
Yes, sir. I understand. So, Your Honor, so in that regard, my client is requesting, he has a job, children to support, one child with mental illness. So what my client is asking the court to do, would the court consider reducing his bond to a $10,000 bond, cash or surety, with a tether? That more than protects the interests of society in general or the protection of the alleged victim in specific. It would allow my client, if he can convince the parole officer to lift the parole hold, which we don't know, but it would certainly give him an opportunity, Judge. And that's all he's asking for, an opportunity.
That's the other thing. Yeah, I love it when we get up here and it was half the story, because I think the other half of that story about the adjournment was contacting parole to figure out what they were going to do. I haven't heard anything about that.
Yes, he did contact. I've been in touch with parole officer myself, and the court saying depends on what's happening with this case. That will determine the whether there's going to be a parole violation charge or not. So everything is up in the air, and all I'm asking, Judge, is to please give the man a chance to maintain his employment and look after his family.
But what are they going to do with it? Because if he gets out, That's part of the problem. If I give him a bond, if I gave him a PR, I'm not saying that I would, but if I give him a PR, but they didn't just grab him up, what have we done?
Oh,
That's why they were supposed to be. Both sides were supposed to do something or try to do something. So,
and Your Honor, absolutely correct. And what my client informs me is he does have another place to stay, a stable place to stay, and we'll communicate that with the parole officer. And it's a big if the parole officer would even lift the parole hold, Judge. We don't even know that. But I'm saying you could certainly, and we're
This is an important legal reality. In domestic violence cases, alleged victims sometimes become difficult to contact for many different reasons. The judge is acknowledging a challenge courts face regularly, but that doesn't automatically mean the case disappears.
asking you to please at least give it a plausible chance of success, a chance of success. The, the, the court is well familiar with the GPS tethers, set whatever parameters the court desires. There's no danger to anybody, Judge. And the man can work and help support his family and pose no threat to anyone, Judge.
Mr. Cook.
I want to make sure the record is clear on certain things. It is absolutely correct that at the last pretrial, which to my recollection would have been, I believe, June 1st, if my notes are correct.
Yes.
At that time, I believe defense counsel asked to set the matter for final settlement conference, and the people asked instead to adjourn the matter for a pretrial to give the people an opportunity to discuss with the victim, because by that point, the case was not even, I believe, 10 days old.
Right.
And we had not had an opportunity to discuss with the victim. At that time, I don't know if I made the representation on the record or if it was just in a conversation with Mr. Mack, but my notes indicate that part of the reason for adjourning was to potentially set it for a bench trial at an earlier date than the August FSC in order to get this case heard as expeditiously as possible in the event that the people were either unaware if they could proceed or unable to proceed. I had confirmation from the victim they would not be interested in prosecution. I am still of the opinion that I want to get this case resolved as soon as possible in a way that is fair both to the defendant and the victim. And to that, I had a conversation with Mr. Mack this early afternoon, morning. I don't remember exactly when, but it was earlier today, where I told him we can set it for the earliest available bench trial date if the court and defense counsel wanted to, in order to get this matter heard before the August FSC. Because contrary to what Mr. Mack stated, I do not enjoy seeing the defendant in custody, and I don't want him to remain in custody any longer than is just and fair. So I would not have an objection to setting this matter for a bench trial. I want this case to be resolved, but I have to take into consideration the victim's wish. We've been given that opportunity, and I've not been able to contact her. We have made efforts, but the simple fact of the matter is we simply do not have good contact information for this victim. Having gotten that opportunity, I'm now trying to get this case heard and resolved as quickly as possible, which I believe would be by a bench trial, as I fully expect we'll reach a resolution on that day. But I wanted to make sure that it is clear that I am not out here trying to get Mr. Johnson to stay in custody as long as possible, that I enjoy a deprivation of his liberty. I am simply trying to make sure that the victim and the defendant both are heard and respected in these proceedings.
Am I allowed to respond to no?
Well, you can respond. I'm just going to say I agree with Mr. Cook. He's been practicing before me. He doesn't like anybody sitting in jail. And frankly, there are times where he doesn't have a problem with somebody being released, but the court does. And so, Mr. Mack, I get attorneys have to do their job and everything, but people just be fair to each other. Because he doesn't attribute you representing this defendant as that you want anybody that beats a woman to walk out there. He's not saying that. So,
Can you consider $10,000?
what am I setting it for?
Well, Your Honor, it would be setting it, allowing to be scheduled for a final settlement conference August.
Jury final settlement conference will be set for
August 7th.
August 7th, 2026, 9 a.m. Jury selection if necessary. August 10th, 2026, at 8:30. Both of those proceedings are in person. What I'm going to do, reference the defendant's bond, is I'm going to continue the defendant's bond as it is. If the defense counsel, through the parole officer, indicates that the defendant would not be taken into custody, basically would lift the hold at this point. The court would consider reducing bond.
All right, Your Honor.
Thank you. Are you almost ready?
Obey El Ahmad.
You're obeying. Okay. All right. Where are we on this case?
Well, we have we need, my client's owed some money. And June rent hasn't been paid at $26.50. The water bill, which you ordered him to pay at the last hearing, I wasn't here, of $2,092. My client paid it, but the tenant needs to pay him for it. There's late fees, there's court costs, et cetera, et cetera. It comes to $5,475.
5475.
Your Honor.
All right. What's your position on this, sir?
So me and Mr. Hussein had come to an agreement to set aside the water bill where I would pay them directly, over a span of time. They gave me a September kind of deadline before fees get assessed. He agreed to that. We're back here. I'm willing to pay, obviously, what is owed. Just to kind of try to come to an agreement in this previous week. Couldn't come to that, so now we're.
So how much is the water bill?
It's $2,092, Your Honor, except that my client's paid it. He's looking to be
I heard you. I
Okay,
hear.
sorry.
2092.
Yes, Your Honor.
So I have 3,383 owing outside of the water bill. Is that right?
My cost. I have to do math, Your Honor. And what did you come up with? I'm sorry.
I came up with, I don't know.
I
Did the math. Oh, 3383.
Yes, Your Honor, that's what I came up with as well.
All right. What did you want to say, sir?
I'm in agreement with the June rent. That's understood. I'm agreeing with the 2092 for the water bill. I just want a little bit more clarification where everything else gets put into that.
Do you have that?
Yes, Your Honor. June late fee is $140. He hasn't paid June rent yet. It's up to $140.
How much is monthly rent?
Pardon me?
$26.50.
Okay, go ahead.
Court costs for last time and this time are $202.
How much?
$202 total for the two court appearances.
How do you get 2 court appearances?
He
I was here last time. That was not
Okay, I know, but we're charging per appearance?
I had to file twice, pay money twice to the court.
You had to do what?
Pay twice for the two different court documents. Two dockets. First one was dismissed because
Okay, and he doesn't owe you for that.
I mean that wasn't the judgment, sir.
What?
The judgment, the court cost.
What's in the judgment?
The court cost the last time.
You issued a prior judgment, Your Honor.
Okay, so if I issued a prior judgment, why are you asking for it on this judgment?
I guess because it hasn't been paid. So like, and the what?
When was that prior judgment?
When was it?
It was March.
March, okay.
It was issued for March 10th.
I'm sorry? Hold on a second, what? Oh, yeah, that was the one. So hold on a second. I don't know why I did not, on that prior case, and I'll get it. My staff just reminded me, I didn't issue the writ because the amount of the judgment had been paid in full.
That was really, he went ahead on the rent, but did not pay the utilities. So he went ahead in the rent, but he did not pay the lost judgment completely.
I don't even know what you're telling. On that previous case, you filed a writ or for a writ of restitution or an order of eviction.
Right.
I refused to sign it because based upon the affidavit, everything had been paid. So I don't know how I get here today and you're trying to charge something in that other judgment which has been deemed paid.
That case, we did the final tally and it came up to be this amount. We did not went ahead and charge him for any extraordinary amount. We try to be fair as possible.
No, you're not being fair. The writ was filed. I deemed that the writ had the previous judgment had been satisfied. I'm now here today and you're trying to charge for something that was on that previous judgment that has been satisfied.
He went ahead and
So you explain to me where fairness comes in that one.
right. So okay, the last judgment was $5,691. He paid $6,400, but he went ahead on just hang on a second. He went ahead on the rent. So actually, that was not actually $5,691. It's actually $5,691 plus
You need to go to an accounting school.
26.
That's not how it's done.
Right.
That is not how it's done.
I mean, he screwed it up. So
What?
I
He
mean,
didn't screw anything up. You did. He didn't. You filed a writ saying that the amount that was on the judgment had already been paid. Why are you chewing gum in my courtroom?
I'm sorry. Sorry. So, Judge, actually, it was $5,691 plus 26.
All right, I'm going to tell you what. You can sit up here and argue math with me all day long. I'll go toe to toe with you. He satisfied the judgment. You can't get the money again. I don't care how you do your accounting. I'm not going to grant him a judgment today because I can't be clear of what you're charging him.
Well, sir, we know he owns the June rent and he owns he admitted he owes the water bill. He owes the June late fee. If we won't add in the court costs, we'll take away everything.
I have questions about all this math at this point.
I mean, we can just,
Yeah, I mean, well, so
in that case, Your Honor, he owes the March rent too. If your judgment is satisfied and he owes March rent at this point.
How does the judgment was issued in March.
Yes, sir. But
So how does he owe March rent? He's
Because-
set.
I understand.
Not going to happen.
And your
I'm not going around and around with you two. You get your numbers together. You can come back to me on the 26th. You can tell me exactly what it is, but I suggest you have it in writing, everything laid out to me because I don't trust your math. I don't trust your accounting, and I'm not giving you a judgment based upon what you're trying to represent to this court.
Now the defense shifts strategy. Since dismissal isn't happening, They're asking for bond reduction. Notice how they're emphasizing employment, family responsibilities, and even a GPS tether. Those are all factors courts often consider when evaluating release conditions.
But
June 26, 2026 at 2 p.m. Thank you. We'll see you then. You right there.